I am Veronica Ukrainetz, Associate Legal Counsel with Ascent Employment Law. My practice is exclusively restricted to supporting employers. Today, I am going to address employee leaves of absence and the employer's obligations when an employee goes on a leave of absence. I will be focusing on the Employment Standards Act of British Columbia, which for the most part applies to employees working for employers whose organizations are contained in British Columbia. There are certain exceptions, such as employees covered by the Canada Labour Code and those in self-regulated professions, such as lawyers, doctors, financial advisors, and realtors. Under the Employment Standards Act, employees are allowed to take a leave of absence and to maintain employment for a number of specific reasons. These are considered job-protected leaves of absence. For convenience going forward, I will refer to the Employment Standards Act as the Act. In all cases except one, an employee does not need to be employed for a certain amount of time to take a leave. The one exception is the short-term sick leave provisions of the Act, which apply after 90 consecutive days of employment. In addition to protecting employment during a short-term or intermittent sick leave, the Act sets out several reasons for which an employee can take job-protected leave. These include maternity and parental, family responsibility, compassionate care, critical illness or injury, having COVID-19 or getting a COVID-19 vaccination. As well, job protections exist for reservist deployment or training in respect of the disappearance or death of a child, where an employee is experiencing domestic or sexual violence, bereavement leave, and for jury duty. Ideally, an employee will provide advance notice in writing of the need to take a job-protected leave, although this is not a specific requirement in most cases. The employer may request satisfactory proof to support the leave. In some cases, such as maternity, parental, compassionate care, or critical illness leave, an employer may request a medical certificate. As of fall 2025, employers will not be permitted to request medical notes to support a short-term sick leave. Satisfactory proof in the result will be very contextual and dependent on the circumstances and the nature of the leave requested. If an employee is on a job-protected leave, their employment must be considered continuous. The employee must receive any wage or benefit increases that they would normally have received had they not taken the leave. The employer must also continue to maintain the employee's enrollment in any pension, medical, or other plan beneficial to the employee if the employee wishes to do so. The employer must also continue to make payments into these plans as though the employee was not on leave. Where an employee is also required to make contributions to these plans, it is crucial that an employer make this responsibility clear to an employee in writing. The employer must also continue to calculate all service-based entitlements as though the employee was not on leave. For example, if the employee on leave, but for the leave, would have moved from a 2-week vacation entitlement to a 3-week vacation entitlement, the employee must be credited with a 3-week vacation entitlement despite the leave. The employer must not change a term or condition of employment because an employee is on a job-protected leave. And the employee has a right to return to their previous position or, if it does not exist, a comparable position. These can be difficult requirements to meet as the employer's operations will continue to evolve while an employee is on leave. However, if challenged, the employer must be able to establish that the change to terms or conditions of employment or inability to return the employee to active duty has nothing to do with the employee taking a job-protected leave. One final point. The only leaves which are required to be paid by the employer are the 5 days personal illness or injury leave and 5 days of paid leave respecting domestic or sexual violence. All other job-protected leaves are unpaid leaves. However, the employee may be able to apply for federal employment insurance benefits. The overall concept is that the employee ought not to experience any penalty or setback to terms and conditions of employment as a result of taking a job-protected leave. If you are uncertain whether the Employment Standards Act leave provisions apply to your organization and the extent to which these leave provisions protect an employee's employment with you, please reach out to any of the lawyers at Ascent Employment Law.